have his moments where
Staring. You just stare.
literally we've done it for like 5 minutes. it's like, I think you would find it terrifying. We just literally look at each other and like
when
time.
I found a sociopath.
And like time stops.
Yeah.
But like that's just how it's been for us from the beginning.
No, we're like, oh my god, there's not enough time.
Oh.
And they score again.
Yeah.
Again.
It's like, oh my god, I forgot to tell you something else.
I think that's cute. You guys are really cute.
I think it's more than cute.
They won the Stanley Cup.
I think it's amazing.
Yeah.
And then let's just do one almost like super close.
Yeah.
Can you guys frame up on the Sebastian on you?
Yeah.
We'll just do like our lips are right next to each other.
Yeah, gotcha.
But I think you should start talking.
Okay.
Do you know what I mean?
Yeah.
Yeah.
Okay, ready? Still rolling.
Don't give it to them.
And
They want it. Don't give it to
they
them.
score.
Just
Right.
keep restraint.
Yeah.
Four.
Just do a little bit of restraint.
Ryan, come on back. And the couple by the bar walk towards us, cross. What's that? No, your name, sorry. Ponytail lady.
And then-
Cross this way,
Let's
cross
do
this way. Take your day, cross this way.
I feel so nosy.
I know.
I feel like
And my-
just noses.
And my nose is so big.
Yes, I was hoping that we could address this. It's not too late. Just gotta shut down. We gotta call an insurance month and just deal with that.
Yeah.
And then,
Cut.
just kidding.
No, it's true. That's why we hired Jenny Slate too. Our noses.
Hi, friends. It's Katie from Without a Crystal Ball. Welcome back to my channel. You know, we've been talking so much about this Blake and Justin situation, and I'll tell you one thing, I'm definitely down this rabbit hole. And one thing I've been thinking a lot about are these issues that I've been noticing in Blake Lively's complaint. And I'll be quite honest, I see deficiencies on both sides when it comes to these legal cases. I'm not going to say I don't support Baldoni and Wayfair, but I definitely can see that there are some issues in their complaint and some obstacles they might have to overcome. But when it comes to Blake Lively, something that's been glaring at me and really in my face for, I don't know, since she filed this, was that when she filed her complaint, she basically stated that she had exhausted all of the administrative processes in order for her to sue. And we kind of touched on this yesterday, but we really didn't discuss it in great length. But when she decided that she was going to sue Justin, she decided that she would file for an immediate right to sue in the state of California. But an immediate right to sue in the state of California doesn't give her the right to sue in federal court. And this is a huge problem. Uh, I- for the first time in Jed Wallace's motion to dismiss, we're actually seeing the letter that she got from the Civil Rights Department. And it says that this letter informs you that the above referenced complaint filed with the CRD has been closed effective December 20th because an immediate right to sue notice was requested. So she filed it and requested the immediate right to sue the same day. So they didn't even have a chance to investigate, and they're not going to investigate. The letter is also your right to sue according to the government code. And it says, but in order to obtain a federal right to sue notice, you must contact the U.S. Equal Employment Opportunity Commission to file a complaint within 30 days of receipt of this CRD notice of case closure, or within 300 days of the alleged discriminatory act, whichever is earlier. So in order for her to obtain a right to sue in federal court, she had to go to the EEOC, but she couldn't go to the EEOC until she got the one from California. And she still, to this day, has not provided evidence that she has filed a right to sue or filed a charge against Wayfair. And here's the issue. They stated, Brian Friedman, that they're not going to do a motion to dismiss on the front end, but they could ask for a summary judgment. And part of the summary judgment happens after discovery, right? So if they go through the discovery process and they take depositions and they find that Blake's claims don't add up and they can't produce the actual discovery evidence that makes her claims a fact, they can put together this very long document that itemizes what the actual statements of the case are and how hers fails to meet these stated claims. And one of the issues they'll be able to bring up in a summary judgment would be that she doesn't have the legal right to sue them under federal law because she hasn't filed for an EEOC right to sue. So I have some suspicions about why she may not have done this step, but I still don't understand any of their decision making processes. But to give you an understanding, in order for her to sue in federal court, she has to get what's called the right to sue letter from the EEOC. And they describe it as a charge of discrimination. Okay. And it says all the laws enforced by EEOC, except the Equal Pay Act, require you to file a charge of discrimination with us before you can file a job discrimination lawsuit against your employer. In addition, an individual, organization, or agency may file a charge on behalf of another person in order to protect the aggrieved person's identity, but there are time limits for filing a charge. The laws enforced by the EEOC require the agency to notify the employer that a charge has been filed against them. So they haven't, if she doesn't file this with the EEOC against Wayfair, the federal government didn't have an opportunity to notify the employer, Wayfair, that they had a charge against them. And it says a charge of discrimination can be completed through the EEOC public portal after you submit an online inquiry and we interview you. Filing a formal charge of employment discrimination is a serious matter. In the EEOC experience, having the opportunity to discuss your concerns, EEOC staff member in an interview is the best way to assess how to address your concerns about employment discrimination and determine whether filing a charge is appropriate for you. At any event, the final decision to file a charge is on you and you alone. The EEOC portal will provide special directions for quickly providing necessary information with the EEOC. The laws enforced by the EEOC require the agency to accept charges alleging employment discrimination if the laws do not apply to your claims, if the charge was not filed within the law's time limit, or if the EEOC decides to limit its investigation, the EEOC will dismiss the charge without further investigation and notify you of your legal rights. So, one of the biggest problems for Blake is that in order for her to file a complaint of sexual harassment and to qualify under Title VII, which are two of her counts in her current complaint, she would have had to file a formal charge with the EEOC within 180 days from the day that the discrimination took place. So if she's claiming she was discriminated against through sexual harassment, she had 180 days from the time the incident happened in May of 2023 to file that claim, but she didn't. Instead, she opted to go through internal processes to remedy whatever the so-called harassment was that she can explain. And it says on their website that time limits for filing a charge with EEOC generally will not extend while you attempt to resolve a dispute. Now, she might try to argue that the harassment continued by the smear campaign, but I think it will be hard for her to prove the smear campaign. So now there's several reasons why she could have skipped this step. I can't say why she skipped this step, but she clearly does not have a federal right to sue because she would have had to go through this process with the EEOC after she put out her complaint, which was on the 21st to the New York Times. She subsequently then filed a lawsuit within like 10 days, which would have not been adequate time to go through the EEOC process. And the EEOC is a completely different beast than going to your state because in the state, you don't have the same sort of stringent requirements that the federal government has. But the EEOC is a federal organization, okay? It's a federal entity, and you can actually face federal charges if you make a false statement or misrepresentation during an EEO investigation, and it can be considered a crime because federal law prohibits making false statements or misrepresentations to any federal agency, including the EEOC. So every single person that is involved with an EEOC, including the person that files, is required to be truthful. And every single person that's involved, because they're required to be truthful, can face penalties. There are potential penalties, which can include criminal charges. Now, the law that is cited is 18 U.S. Code 1001 on statements, and it states that anyone that's under the jurisdiction of our government, if they falsify, conceal, or cover up by any trick, scheme, device, or material fact, makes a materially false, fictitious, or fraudulent statement or representation, or makes or uses any false writing or documents, knowing the same contain any materially false, fictitious, or fraudulent statement or entry, shall be fined under this title and imprisoned of not more than 5 years. And if the offense involves international or domestic terrorism, it's more. It does not apply to judicial proceedings. So you can make a false statement in a judicial proceeding, but you can't make a false statement to the EEOC. And it also is interesting to me. So she goes to the California Department of Civil Rights to get the letter there, but then she doesn't file in California and she goes to New York. Weird choice. And she also files in federal court. And then she uses the complaint to charge them with 2 separate charges under the EEOC's Title VII, which is anti-discrimination. Yet she doesn't have a letter from the EEOC that tells her she can sue. She hasn't filed a formal charge. And if she would file a formal charge, it would give the opportunity for Wayfair to respond to the claims from the federal government. And if the charge is not moved forward by the EEOC, she could still sue civilly, yes, but she has to exhaust that process, and she didn't. So if she's not willing to go on record with the federal government, because if she lies, she could go to prison, but she can make these statements in a court proceeding and not face perjury or face charges for making false statements by filing a complaint, it seems a little bit strange. If you truly had a claim of discrimination, you would go through all the legal steps. So in this case, it's another time that she doesn't go through the formal process. She doesn't file a formal HR complaint. She doesn't go to her union. She doesn't get a formal investigation from the CRD. She doesn't file a charge with the EEOC and then files a lawsuit using Title VII when she can't. The laws for federal claims are very specific. If you don't have a right to sue under EEOC, you cannot file a discrimination case. Now, a judge can throw this out if they wanted to, right? So they don't need a motion to dismiss if they find out that she doesn't have the EEOC. But Brian Friedman and Baldoni and Wayfair could, through discovery, also learn that she doesn't have the EEOC, which she doesn't reference, and she should have. They can get that tossed in a summary judgment if it doesn't go to trial. Like if they're able to get through all of discovery and find that there's no basis for these claims, they can do what's called a summary judgment. Or at trial, they can have these tossed because, again, she doesn't have a right under federal law to bring these claims. I just keep finding it strange that all of these claims are brought, but yet she's lacking the steps needed to bring them formally. I never want to discount sexual harassment, right? I hate the fact that we even have to talk about that because when someone brings a claim, you want to believe them. But if someone truly was a victim of sexual harassment and they believed wholeheartedly that they were the victim, they would go through all of these steps instead of going civilly. And here's the thing, if she goes through the CRD side and they do an investigation, that could take years. And she's not going to get the kind of money unless she files civilly. Equally, the same thing applies with the EEOC. So much of this to me just feels like she wants money, which she does. I mean, she's seeking damages, and she's in her motion to dismiss claiming she gets even more damages because she's filing this. And there's this one law in the state of California, which she's again not suing in California. So she wants the protection of California laws, but then she didn't file it in California. And truthfully, when you understand California law and you know that there's a civil extortion law that can be used against her and can be filed, and there's an invasion of privacy and false light that's not in New York, is there any question that she didn't file in California under federal law? Because if she filed in California, they wouldn't be able to argue that the civil conspiracy or the civil extortion can't be pled, because their biggest issue right now is they keep saying that they don't have the facts to plead civil extortion, and that this isn't a California case, and so they can't be sued under California law in the state of New York. Okay, well, if she would have gone and filed in California, they could have done that, and her right to sue was for California. So if she knows there's a law that they can counter with, what better way to go out of the state and go to New York? Generally speaking, in federal court, even if parties have different jurisdictions of where they live, you need to sue the parties in the jurisdiction of where the party that you're suing resides. And Justin and Wayfair Studios are a California company, and they're based in California. And she didn't sue in California. A lot of the issues happened in New Jersey, yet she's not suing in New Jersey. Some of them happened in New York, but not all of them. So she's picking a venue that is convenient for her because she's a resident of New York, but it's not convenient for anyone else because no one else is involved is an actual New York citizen. To help you understand just how flawed this complaint is, she's bringing her very first cause of action is sexual harassment in violation of Title VII against It Ends With Us movie and Wayfair. It says that at all times mentioned, Title VII was in full force and effect and was fully binding upon defendants as employers or joint employers, and applicable to Miss Lively as a member of a group protected by the Title VII prohibition against discrimination and harassment. It says that her gender is protected. It states that they discriminated against her and were subjecting her to harassment and created a hostile work environment based on her gender. That it was pervasive, and it created such a work environment that a reasonable person would perceive and did perceive it to be hostile, intimidating, offensive, oppressive, and abusive. They go and state that they get this claim under Title VII. It's the very first charge. And then the second charge is retaliation under the same clause. Okay. And they're saying that the law was in full force. That doesn't matter if the law was in full force. What matters is if Blake Lively went to the federal government and sought a right to sue and filed an actual charge. Without an actual charge, she can't file these claims. She can use huge language and say that the law was in full force, but if she goes to the actual website for the EEOC, it literally says if you filed a charge under Title VII or under the American Disabilities Act based on a disability, you must have a notice of a right to sue from EEOC before you can file a lawsuit in federal court. You must allow the EEOC 180 days to resolve your charge. Although in some cases, the EEOC may agree to issue a notice of right to sue before the 180 days. If you filed your charge under the Age Discrimination Act, which she didn't, she's using the sexual harassment one, and she's not filing the charge. It literally says you cannot use these claims unless you file the charge. So when she goes to the federal website, one of the first steps they would take was trying to get a mediator involved to help Blake and Justin's side to actually come to a settlement or an agreement and work through the dispute. She didn't do that. And if it's not sent to mediation, and if mediation doesn't resolve it, then they might do an investigation. It says, you will receive an email once we receive the position statement and it's available for your review, meaning that under federal law and under the EEOC and this process, they give an employer the right to respond to the claims and give them a position of what they believe happened. And it says how we investigate a charge depends on the facts and the kinds of information we need to gather. In some instances, we visit the employer to hold interviews and gather documents. In other instances, we interview witnesses and ask for documents. How long it takes depends on many factors, including the amount of information that needs to be gathered. So if she bypasses all of these, she can use whatever inflammatory language she wants, whatever bold, italicized language she wants. She can state that it is unlawful for an employment practice for an employer to discriminate against an employee because she was opposed and practices forbidden under Title VII, or because she has filed a complaint against conduct prohibited under Title VII, as Miss Lively did when she complained to Wayfair. She's making these huge claims, but she didn't go to the EEOC. She did not exhaust the administrative process. And she's claiming these because under these laws, she could get punitive damages because she can claim malice. When Brian Friedman said that their complaint had so many issues that they just were going to respond to it because it was such a mess, which basically it is, this is what he's talking about. You cannot, these are the two biggest claims in her lawsuit, right? They are the most significant in terms of like the impact to an employer and the punitive damages that she could receive. And yet she doesn't have permission from the federal government to even bring these claims against him. She's using language that a PR strategist might use to say things like the laws were in full force. But in her counts, she doesn't state that she exhausted all of her rights, that she received a right to sue, and that she has that right here. And the letter that she got from the state of California flat out says that their right to sue does not give her a right to sue federally. It only pertains in California. It says to obtain a federal right to sue notice, you must contact the U.S. Equal Employment Opportunity Commission to file a complaint within 30 days of receipt of this notice, or within 300 days of the last alleged discriminatory act, whichever is earlier. Meaning, she got this on December 20th. She had until January 20th to get a right to sue letter from the federal government. And she didn't, because when she filed her amended complaint, she didn't file the federal right to sue notice. She's given no indication to the court here that she has this right under the law to even bring these counts. So these counts could likely get tossed before there was even a trial. And they're obviously the most significant because they're the very first two she brought. So if her first two counts aren't even valid because she doesn't have the right to sue, can you really trust the rest of the counts? This is why Justin Baldoni and Wayfair and It Ends With Us and all these defendants are saying number 2 affirmative defense, she lacks standing to sue. If she doesn't have that letter, she lacks standing to sue. She cannot sue. It's illegal. She doesn't care about the law, clearly. They can easily ask for a dismissal. And quite honestly, the judge in this case could dismiss those 2 counts because they lack jurisdiction. They don't have the capacity to enforce these 2 counts because they don't have the approval from the EEOC because she didn't seek it. And if she doesn't seek it, the court can't rule on it. And it concludes the involvement of the EEOC. She never went to the EEOC. So how can she then bring these claims other than for PR purposes? So are you shocked to hear about this? What are your thoughts? Is this why Brian Friedman is saying there are serious problems with her complaint? Tell me in the comments below. Make sure to give this video a thumbs up. Please subscribe to my channel if you haven't subscribed and click the bell so you never miss a video. Thank you so much for watching. Bye, guys.